Think about it, Dan. I mean, he needs all the equipment there. He needs, like, the defibrillator. He needs, like, the ability to, like, intubate him if he can't breathe. He needs to have epinephrine, whatever it takes to, like, get a heart restarted again. The whole point is he shouldn't be doing any of this. He should know better. This is a guy playing some kind of kooky medicine in the bedroom, giving this man drugs that literally could kill him at any given moment if it's not administered and monitored properly.
There's no question he did a lot of things wrong. The question is, does it rise to the level of gross negligence that would make it involuntary manslaughter? And that's what the trial will decide. You know, the defense is suggesting that they may say Michael Jackson ingested this orally on his own, and if that is part of their defense, then there's going to be a lot of battle of the experts to determine whether the residue that was found in his stomach is enough to be consistent with that. Although even if Michael Jackson did ingest on his own when the doctor was out of the room, the question is, why was he out of the room when he was administering propofol, a really powerful drug? Why didn't he call 911 right away? Why did he say he was only out for 5 minutes when cell phone records show he was out for longer? So there are a lot of questions here. It's going to be a tough case for the defendants here.
And even if he did, if he did take it himself, he's already under the influence of the drug. And so if he sits up, you know, you hear all the stories about Ambien, which is everybody takes Ambien. I mean, well, people with sleeping problems, and then they eat the refrigerator and they don't remember it, or they get in a car and they drive. You know, so if he's under the influence of this and he sits up and the drug is within arm's reach, you know, that still comes under the gamut of the doctor's responsibility. So even if he takes it by himself, and there was only 0.13 milligrams in his stomach, and the drug isn't taken by mouth, and I think it runs through the system incredibly quickly and causes severe diarrhea, so I don't think, you know, they're going to have an easy time fighting that battle, but that's still his responsibility.
You're like knocked out. How, Dan, are you going to be able to swallow an additional dose? I mean, this is administered, you know, intravenously, so it's just, this whole thing is a little bit suspect, and the trace amount of propofol that they said was found in the stomach, 0.13 milligrams, they're hinging their whole defense on that to say, oh, this was enough. That put him over the edge and killed him, so therefore it's Michael Jackson killed himself with propofol and not Dr. Conrad Murray, therefore no gross negligence.
I think it's because the defense is desperate, because this is not supposed to be a sleep agent. It's not supposed to be administered for that purpose, and they can't say he wasn't administering it. He can't say he wasn't doing something inappropriate. He can't say he failed to call 911, he failed to save Michael Jackson, he failed to have the life-saving equipment there. So that stuff is not going to be contested. All they can go with is Michael Jackson ingested it on his own and hope that they can stop it rising to the level of gross negligence.
Well, this is interesting because the prosecution, the defense basically wants to put in a study from a Chilean doctor who had a study of students, I guess, who voluntarily drank the drug. This is great. Or a study of pigs who received it rectally.
With a rectum.
I mean, you can't make it up. Like, when pigs fly, that's what I got to say about that defense.
And whenever you offer studies, the reliability of those studies is always at issue. And if they offer something that seems flimsy, that's just going to undermine their credibility. So they should tread carefully there.
I agree.
Now, also, you've got Rebecca, the defense has one of its lawyers is J. Michael Flanagan. He says he's the only California attorney to ever try a propofol death case. So I guess he was involved in a case representing a pair of nurses charged with killing a cancer patient after the propofol was given without proper authorization, because you're supposed to have an anesthesiologist do it, not even just, you know, a cardiologist or whatever. You're supposed to have an anesthesiologist. It's that specialized. Anyway, he was able to get his client acquitted on that, so, you know, maybe that's going to help Dr. Murray. I don't know.
But that's like saying you defended one person for stabbing, so you could successfully defend another person for stabbing. You know, they're different cases. One was, I believe, in the hospital. This one's in a home. So, you know, they're very different.
And the other thing is that, you know, Michael Jackson, a national treasure, and struggling with his trying to have a comeback, and he was just so exhausted. This does not allow him to have a restful sleep on top of everything else. So he's under so much stress. He's working so hard. He's absolutely exhausted, and then his body, with all of this medication in him, is not even getting to reach the level. I guess it's the REM sleep, because it's a fake drug-induced sleep. So that's not helping him to begin with. So it's all just so wrong.
Well, and there's the one witness who I thought was compelling who is going to testify, which is Sherilyn Lee, who is a nurse nutritionist who had been giving Michael Jackson vitamins, etc. He asked for Diprovan from her, and she's like, you know, Michael, listen, you can't take that drug. If you do, the only problem is you ingest that you may not wake up from. So there's plenty of evidence to show that this is, what he wanted, but it doesn't, in my mind, legally speaking, absolve Dr. Conrad Murray from the purposeful choice that he made to accept money to give Michael Jackson this drug in an improper setting without proper medical equipment, to perhaps resuscitate him if need be. I mean, the fact that he's giving it to him in his house, in his bedroom, and that he's not an anesthesiologist and administering it right there, to me, seems to be conclusive proof.
Yeah, look, he was offered a lot of money, $150,000 a month, and he was willing to undermine his medical training and the medical responsibility that he swore an oath to uphold in order to make this large amount of money. Maybe he was also transfixed by the fact that it was a star that he was working with, and he certainly acted very irresponsibly.
Okay, well, they're saying that this is, Michael Jackson's a guy that wasn't, looking for drugs to get high. He just wanted desperately to have sleep. He was exhausted. Joey Jackson joins us in studio. So great to have you here.
How you doing?
Good. We had a little update report from Madam Housley about the, Michael Conrad Murray trial, Michael Jackson case. And so he's doing this whole defense, saying that there's some propofol in the stomach, and let's get your kind of thoughts, takeaway before we move to the next topic.
The biggest problem, Kimberly, is that they don't have you as the prosecutor.
Yes.
Okay?
My old office.
So they're going to have issues to begin with. But, however, going to be a tough case. I think that from a defense perspective, what you have to balance the whole case against is whether or not the doctor should have let those drugs be available, whether the standard of care provided was acceptable, was it a gross deviation from what normally would be expected. And the other thing, Kimberly, is that you got to walk the tightrope. And the reason I say that is, you don't want to blame the victim too much. You have someone who's dead. Obviously, there needs to be some responsibility found as to who's responsible. And to say or suggest that he's a drug addict or he would have killed himself anyway, I think it's inflammatory, and it could really upset the jury. So you have to walk the tightrope, and you otherwise have to say that Michael Jackson had problems. He did suffer from certain drug addictions. Maybe he took this and he did it on his own. And if they walk that tightrope, they got a shot, but it's a tough case.
All right, well, here we go. Let's move on to our next legal topic from the Chicago Tribune. We have Bob Ward found guilty. This has been one of our headlines here on FoxNews.com. What do you think, Dan, of this case? I mean, people, it seemed like he might have a defense. I mean, as a prosecutor, I'll say, I didn't see it, but some people thought perhaps he had somewhat of a credible defense to say that, because there was just some ambiguity as to exactly what happened.
Right. Well, first of all, he called 911 to say that he shot his wife, and he said he was sorry. And she was shot at close range. Yeah. Now they're saying that sorry was more of a emotional, psychological sorry, not a sorry for
guilt.
admission for guilt. There's a former girlfriend who also came forward publicly saying that he was abusive to her and held a gun to her at one point. And, it's a tragic case. He was also going through a bankruptcy proceeding. She was supposed to testify against him. There's a lot of factors here. And it's hard to imagine, I'm a former prosecutor, it's hard to imagine why someone who has his wife accidentally shot or shoots herself, why someone would say that he shot her and he's sorry, making what seems to be a clear confession.
Well, he's looking at a mandatory minimum sentence, Joey, of 25 years, which is essentially, they're saying, like a life sentence because he's 63 years old. But he's going to do a motion for a new trial. He's going to appeal it.
Yeah.
I mean, what's your overall assessment of it?
It's tough. It's interesting. What does Rebecca say? I agree with whatever Rebecca says. How you doing, Rebecca?
How you doing, Joey?
I'm good, thank you. Listen, I thought a lot of talk has been whether or not the Casey Anthony verdict had any effect upon it. Similar circumstance with regard to where it was tried. I thought it could have gone I thought it could have gone either way. I really do. I mean, I know, I know what you're saying in terms of listen, it was a confession. But I think the defense did a good job in saying that it wasn't a confession. It was about him feeling morally responsible, and as a result of that, he said, I killed her, in a moralistic sense, not a confession sense. The problem is, though, when you talk about a struggle over a gun, but then you have a direct hit that's right between the eyes, and you have the 18-inch distance, it leaves something to be desired. And the whole issue about, whether or not she was suicidal kind of goes against her interactions with family, her signing up for Facebook, so it was a very difficult case, I think, for the defense to prevail on, given that. So did the jury get it right? I never quibble with that, Kimberly. I don't know whether they got it right, but look, jurors do what they do, and we have to respect the verdict.
Yeah.
Well, the defense doesn't. Go ahead. I'm sorry.
Go ahead, Rebecca, and then you can.
I think that's the problem was the 18, it was too far away, it was right in her face, and it started out with, I shot my wife, she's dead. And then it went to, I was struggling with her, and the gun went off, and then it went with she's suicidal. And I think whenever you make a statement, it always comes back to haunt you, and there was no problem with it haunting him here. And the suicidal, like Joey just said, you know, you have a daughter saying, I just talked to my mom, and she told me that she was going to lunch with my dad. You have a friend that she hadn't been in touch with, reconnecting, saying she sounded great, talking about having grandchildren, and that does not sound like somebody who's suicidal. You have that perfect timing that she's going to testify in a deposition saying that he squandered all of the company's money on gigantic homes and cars. He hasn't paid his mortgage of $16,000 plus in a year, and a former girlfriend saying he's incredibly abusive. So I think that you put all that together and it's a little difficult. But the thing that I found a little bit interesting about this case is how every murder trial lately seems to turn into, you know, bodyguards and drama. So you have the three men dressed in the black and the white that follow the young daughters around everywhere like they're high society, and you have one daughter that's caught in the drama, and her statement didn't help, you know, her dad, and the other daughter who was appropriately very distressed. So I thought that added another little.
Well, they're crying. Isn't that sad, though? And
She
they're
tried
in the
to help.
courtroom, and they don't, you know, they think
Yeah.
like, oh, now you're going to take our dad. They said, how does this help anybody? Mallory testified.
Yeah, you know, and she tried to help, Kimberly, but I think the prosecutor, in asking a very critical question, got her to make an admission. Because remember, she
Talk
said
about
that.
That's interesting.
Yeah, she said that, you know what, my mom changes when she drinks, right? And my mom gets a little bit angry or violent when she drinks. And then the retort to that, from the prosecutor's perspective, well, tell us about that. Did she have slurred speech? Answer, no. So slurred speech is one of the major indicia of intoxication. Couldn't establish that she had slurred speech, you know.
She had antidepressant in her system.
Yeah, she had antidepressant in the system. But of course what happens, Kimberly, is that from the state's perspective, their experts were saying it was a de minimis level. It was not a level that would increase the amount of depression or suicidal thoughts or tendencies. And go figure, battle of the experts. From the defense's perspective, they said, sure, she could be suicidal. So I think ultimately the jury rejected that. And, you know, look, the daughter, I thought to her credit, she tried to testify, and she did seemingly testify truthfully, but if she would have only said, yes, my mom had slurred speech, it would have been, you know, it would have been a different story. But we tell our witnesses to tell the truth, the whole truth,
Joey.
and nothing but the truth, so help us.
We don't tell them to add anything.
That's right.
That'd be bad. I would love to move on to this other story if we could, which is interesting. It's fugitive illegal immigrants. This is a FoxNews.com story, reportedly arrested for sixth drunk driving offense, Dan, in the U.S. A lot of outrage over this, saying, you know, what is going on here? Because this guy had been deported for the same offense, walks right back in, and, you know, once again, like menace to society. You got to be pretty bad and drunk pretty often to get arrested that many times drinking and driving. Yes or no?
Right.
I mean...
Right, in Massachusetts, it's operating under the influence, and he has to be incarcerated for a long period of time. Deporting is not enough. If you could commit a crime and all that's going to happen is you'll be deported and then you could come back, that's not a strong disincentive, clearly, for this guy. So he needs to be incarcerated for a long period of time and then thrown out of the country, and hopefully that will deter other people from doing similar things.
Kimberly,
Go ahead, Rebecca.
After 19 years of doing this, I am, in the beginning, I just didn't think it was a problem, but I have to say after 19 years, I have learned that alcohol is the most addictive drug out there, and my clients, unfortunately, I'm sorry to say, they're coming back for their fifth and the sixth and the seventh after 19 years. And the maximum sentence is a year. When you get a year, you're out in 6 months, and then there's a seventh offense and an eighth offense because
they're just not picking up new offenses when they're in. That's it. They get out and they pick them up again.
Also, alcoholism doesn't make you drive. It makes you drink.
But I will tell you something.
Get behind the wheel.
How about that?
This article is, they don't learn, but this article is about the immigration, and the one thing I can say, Homeland Security, and by virtue of what just happened in this case that you're focusing on, the rules have changed. And in Montgomery County, Maryland, where the jails are, Homeland Security called in and they said, starting in September, every single person that hits the jail, we we want their fingerprints. And the jail said, hey, we don't want to do that because it scares off the victims of dealing with the state, and we're already dealing with ICE, Immigration Customs Enforcement. And Homeland Security said, we don't care that you're dealing with ICE, this is the way it's going to be.
Right.
So every single person that gets into the jail for one day gets turned over to Homeland Security, so everything is getting hooked up now for the first time. That's why this case got hooked up for the first time. So moving forward, I think you're going to see cases like this where they immediately, fingerprints just like this guy, get put into the system, and that's where everything is going from today forward.
Well, two quick things. Rebecca, number one, you cannot possibly have been practicing for 19 years. You look way too good to be practicing for 19 years, all right? That's number one.
That's why I love Joe.
Number two, Kimberly, you know, look, to your point, if somebody has, that's a lot of times, all right? Now, not casting aspersions, but people do things and they don't get caught. So imagine the other times. I mean, you just completely intoxicated every time you go to touch a key to get into a car.
To a family or, of a victim that he's eventually, sorry to say, killed. Yeah, he had 3 in California, 2 in Massachusetts. Yeah. No, I know. The problem is he just going, state to state on a rampage here. Yeah, I don't know what they're going to do. What's the solution, though, Dan, to this situation? Lock him up for however long, and then what, deport him? He came back in.
Well, you need to have felonies for people that commit multiple misdemeanors, and some states have these and some states don't, so that if he's arrested for a 6th, even if it's a misdemeanor, it would be a felony at that point, and he would do serious prison time.
Well, in California, it would have to be a felony if you had this many priors, and they're, priors that you can allege, and you put them down in the complaint, and you can stack time with them.
Right, and then you get real time that means something, and then maybe it'll deter people or at least keep them out for a few years.
Well, you know what, though, quickly, it's difficult because the legislatures in each of the states, I think, have taken this very seriously. And if you look at what has been done, look, the legal age has been, in terms of alcohol, right, that's been brought down. It's first, what was it, 18, then 19, and 21, so they try to attack it that way. Then the level, 0.10, it went down to 0.08, right? Then you figure you make it a felony if you've been convicted within the last 10 years of driving.
Or subsequent offenders.
Exactly, for subsequent offenders. So the legislature has taken this problem very seriously, and you just can't get to everybody. And so I think this speaks to a larger problem. Do we need immigration reform? Well, that's a whole nother debate, and I think that could take us through how many hours of a discussion here?
Now we're going to take a break. We're going to continue this fascinating discussion. When we come back, we're going to talk about the Amanda Knox case. We're going to talk about Fast and Furious latest developments there. We'll be joined by Lise Wheel, my colleague, for the Wheel of Justice. It's not to be missed, let me tell you. And we're also going to get the very latest from Laura Ingle on the Pettit case, the home invasion out of Connecticut. Stay with us.